Hello, welcome. We're going to give it just a few minutes for everybody to pop in, and we'll get our webinar started in just a second. Welcome. We're going to start in just a minute. Thank you so much for coming to Citizens Law School tonight. Okay, we'll go ahead and get started. Welcome again to Citizens Law School. This is a program that the Montana Bar Law-Related Education Committee puts on every fall. It's 8 weeks of Zoom lectures on issues that have to do with Montana law. And the goal is to shed some light on legal issues that are impacting Montanans. My name is Anna Conley, and I'm so excited to introduce Hertha Lund tonight. Hertha Lund is an attorney and she practices out of Bozeman. She's been practicing law for nearly 30 years, and Hertha understands what it means to lose a family business after an ensuing heartbreak after her family lost a ranch when she was in college. She became dedicated to property rights and defending property rights of Montana landowners. Based on her years of being a horseshoer, she understands hard work, and sometimes one just has to pick up the horse's foot, trim it, and shape the shoe to fit. Similarly, practicing law can often be difficult to start, figuring out how to frame issues, communicating ways that end up either favorable or a settlement or a win in court. And Hertha has perfected her work ethic by shoeing horses, and she uses this strength as an attorney representing clients on land use issues in multiple courts. She's passionate about serving her clients to protect their rights. We are very lucky to have her tonight. So I'm going to turn it over to you, Hertha. Welcome, and thank you for joining us tonight.
Well, thank you, Anna. That was an awesome introduction. And I'm so happy to be here tonight. And I am very passionate about property rights. And I think you can all see my screen. Oh, as we go through this discussion tonight, if you want to ask a question, you can go ahead and ask it while we're doing the presentation. Just raise your hand and Anna will call on you to let me know, or you can raise your virtual hand for those of you who are good at that. But as we look at this first slide, how many, think about it for a second, count how many places you can see property rights. This is kind of like one of those slides that they make, we have to do to see if we're whether or not we're AI or whether we're human. But this is a good slide to show you all the different types of property that there are. So I'll give you just a moment, and I will start from the top. At the top of the screen, and I think, can you see my mouse when I move it, the little arrow?
We can, yep.
Okay. That's a dump truck. This is actually our ranch, and that's a little dump truck that sits up there. So that's personal property. And all the land that you see is real property. And coming down this coulee right here in the trees, there's a stream there, and that's water. So that's water rights, which is also in Montana and the other Western states that have the prior appropriation doctrine. That's also real property. Here in this pasture, you can see some bunks that we use to feed the yearlings. Whoops. And that is also personal property. Here's some straw or hay. I think it's hay. It's just looking a little bit, it's carryover. You're always happy to have carryover hay on the ranch. So that is also personal property. And here we have another type of a property interest. There's a road. Right here, it's a county road. So there's it's a county, and then when it turns off here, it's a private road. So that brings in different property rights. And then we also have a stream down here in these trees. And then right here, you have a fence. So those are all the different property rights that exist in this one picture. So what is the definition of property? And, if you think of property and the biggest issue, it's intellectual property. Anyhow, the definition is the right to use, control, and dispose of something that a person or entity owns. Property can be tangible or intangible. It can include water, land, buildings, vehicles, furniture, stock, money, bonds, patents, and copyrights. Also can be livestock, pets, and some species of wildlife in the states that allow that. So, as I mentioned earlier, real property is land and water rights, but not every state. in some states, only land is real property. And then there's personal property, which is technically all the other property rights. So I mostly deal with real property. And if you think about real property, when you have land, you define it by a legal description, and so we can tell where it is, we can tell how, you can measure it, you can do a survey, how big it is. And within that area of property, you have the right to use that property, you have the right to exclude others, and you have a right to lease the property. That means you can rent it for a certain amount of time, for a certain amount of money for someone else. Or, there's other issues that will come up in a minute. We'll talk about other interests in property as we go along. So more about property rights. You can also, on this land that you have a right to lease or granted easement for a wind or a solar farm. So that means they're not taking the fee simple, they're taking one stick in the bundle of sticks. And and those are easements under Montana law. You could also have a right to mine for minerals or drill for oil, so long as you own the mineral rights. Montana has a lot of land where there's a split estate, where the owner of the surface estate does not own the mineral rights. And you also have the right to just compensation. So the Fifth Amendment says that, property shall not be taken for public use without just compensation. It also can't be taken without due process. And there's a similar provision in the Montana Constitution. Well, that's property. That's my mare Mystic. And she's a beautiful Gypsy Shire cross. And I love spending time at the ranch, so I get to see Mystic and my other horses. She would not think she's property, though. She definitely thinks she's a full-on partner, and maybe she thinks I'm her property. So water rights are real property in Montana, and they're really kind of interesting to try to, they're literally amorphous. So if you think about it, I told you about land, you can measure it, you can have a legal description, you can have a survey, so you can know exactly where it is, you could put a fence around it. Even though water right is real property interest, it's still just a right to use a certain amount of water that is diverted from a certain place on a certain piece of property for a certain beneficial use. So to unpack that a little bit more, that stream that you saw on the first slide, there are water rights out of that to irrigate some of the land that's adjacent to it. And the season of irrigation is most of the time, an irrigation right is from like when you could first start irrigating in the spring. So let's say maybe April 1st, and then your water right is based on beneficial use, how it's been put to beneficial use. So then you get to use it until you can no longer use it in the fall. So let's say maybe October 30th or something. And I'm just making those numbers up. But a water right is a very specific use right. It is a usufructuary right, and the state owns the underlying corpus in the water, but the right to use the water is a real property interest to benefit whoever owns that water right. So, and as everybody knows, having a valid water right has a huge impact on the value of the real estate. There are lots of issues going on right now in Montana regarding water rights. We're still going through adjudication, which is the truing up of the paper water rights that have been filed since, Montana first became a state and created a system where you could file for your water rights. And what people did is they said, I'm using that water for, let's say, for mining. And this is how much I use, and this is when I use it, and this is when I started using it, because when you start using it, all water rights are allocated according to priority. And it's the oldest water right wins if you ever have a shortage. And so people filed on those, but a lot of those water rights are what's called paper water rights. They're not true to how it's been used. And the adjudication system is a process whereby people who filed on them they can object to their own water right to make it, to correct it, but neighbors or other people who can be impacted can also object. And that is one way of truing it up to make sure that what the water rights that we have are trued up to what happens out on the ground. And that hopefully they're thinking it will get done in the next 10 to 20 years. And I actually think that's possible, so. Well, there's another one. That's my horse Monk. He's a full-blood gypsy. Gypsies are, they were brought over from Europe and they're mid-sized drafts, and they're called gypsies because the gypsies bred them to pull their wagons, and they wanted a pretty horse that was also strong. I actually use them on the ranch for ranch work and for coaching. Easements are another property interest. And so an easement is, so if you think about when we looked at that first picture and we saw the real estate and the land, that road, there was one place where I told you where it forked to the right, that was a private road. So there's no easement there. That the landowner, in that case, my husband, the family ranch, owns the land around it, and they also own the road. However, the road that was down by the fence is a county road. So there is an easement in the benefit of the county and on that road, and that road can be used by, anybody who wants to travel the county road. And usually there's on an easement, there's a width to that easement. And so what is an easement? It is a stick in the bundle of sticks. And when I say that, fee simple means you own the whole land, everything, and you own it in total, but then there's other parts of it. And so, the use of a road on it, or you could sell that, and there's a lot of issues right now where people litigate over easements. I would say a lot of my practice is litigation, and I would bet I have 10 or 15 cases right now that people argued about road easements. So in a way that happens is somebody buys land and they see a road out there. It's got a 2-track, but just because there's a road there doesn't mean there's an easement. An easement is a recorded document. And so to have a road easement, you have to actually record it and go to court and have that, listed there. So if you're buying or selling property, you really need to be careful to make sure that you actually have an easement. You're selling the land with easements, are you disclosure or not? And the same with water rights. Just because there's a creek, I don't know if we're supposed to say creek or creek in Montana anymore, I can't remember. Anyhow, if just because there's a water flowing through the property does not mean you have water rights. And that's another thing where I've seen litigation is that people buy something, or there's a realtor who sells something and makes claims, and then that's not really what happened. So these are areas with all the land changing hands in Montana and the new people moving here. The places where there's lots of consternation and conflict has to do with easements and water rights.
So
Now,
can I ask a question?
Sure.
When you have an easement case, is it usually about the presence of an easement, or is it more about the scope of the easement, or is it about both? Or what kind of issues are you litigating in your easement cases generally?
It's both. So 2 of the cases I have right now are ranchers, and we have somebody who wants to sell their land and possibly to new people coming in. And so like a generation back, the parents of both of these people who own the property now, they got along great. And so the road, there was not a problem. They used the road, and it goes through my client's pasture. So it's really important that when they have cows out there that they shut that gate so that livestock doesn't get out. Well, now it's not, it's gone down 1 generation, and they no longer keep the gate closed, and now they want to sell it. And my clients are like, we don't want to give you an easement, because if you've been this bad to deal with, and we know your parents, whoever you sell it to can be really bad to deal with. And so, and then they, if you've used an easement for, I think it's 5 years, but don't quote me, I always look it up, without permission, open and notorious is what it means. You can get it by a prescription, which means you can get it by using it. However, you have to use it without permission. In this case, my client's parents gave the other parents, it was all done by neighbors being friendly. So I don't think it'd be hard to get a prescriptive easement. But then there's also the argument, even if you get a prescriptive easement, it is limited to the previous use. So if it was only used as a ranch road or a place to get to and from, buildings for a ranch, whatever it was for that ranch, that is not an easement that you can drive a development through.
Mhm.
So there's a lot of time spent on whether there is an easement and then about the scope of the easement also. And litigation is costly, so you can try to settle it, but we spend a lot of time arguing about the scope of the easement.
It seems like a lot of those cases are kind of butting up against the reality that there's a lot of change in use of land in Montana right now. So you're seeing that firsthand in these cases, it sounds like.
Absolutely, and it's kind of unfortunate because you have two cultures. You have the old culture that is more used to being friendly to each other and taking care of each other. And then you have, a new culture coming in and they're getting away from wherever you're moving from, and they really want their slice of, the the last best place. But there is a kind of a cultural clash. And obviously they come in and they spend all this money. They're like, well, we should have what we paid for.
Mhm.
Yeah.
Yeah. Well, along those lines, we have one question that says, is it possible to revoke an easement?
Depends on how it's written. An easement is a written document like a contract, but most of them are not revocable. It runs with the land. So that is, but if there is an easement, it will be recorded at the courthouse. So it is a document, so you can look at it and analyze it. Unless, somebody's trying to make a case that there's a prescriptive easement, and then they have a claim for an easement, and they would have to get it by litigation and prevail. So those are hard cases. They're very fact specific, and I'd have to say that, I never dreamt when I went to law school almost 30 years ago that litigation would be as expensive as it is now. It is expensive, and I can guarantee you that, just like everybody else's costs gone up, it's not like the attorneys are making a ton of money. It's just expensive to litigate.
Yeah, I've got another easement question here. Does an easement acquired by prescription run with the land? That's a great question. I don't know the answer to that.
Yes, it would, because what you'd have to do is you have to go through the court process. And at the end of the court case, if the person prevails and get in a prescriptive easement, then they will have something that they will be able to file. You're getting in a written document what is historic use based on that doctrine, that if you use it without permission, you could get a prescriptive easement. So then after the court decided it, and after whatever document they ordered to be filed was filed, then it would be run with the land.
Great. And if anybody else has a question, the best way to do it with this webinar format is to drop it in the Q&A.
All right, so I did mention leases. Leases are similar to an easement because it's for a use of property. Like for wind leases, if somebody comes to talk to you about getting a wind lease on your property and they don't call it an easement in Montana, it's a brand new wind company that hasn't looked at our laws yet. A wind lease a document for a wind development project has to be an easement and a lease document. And that's because the easement itself, to be able to capture the wind for wind turbines, is provided, and I'll show you this language before we're done with my presentation. It's by statute one of the easements that are allowed in Montana. But to be able to get all the other uses that they need to be able to drive, well, that's also a road easement, but they have to lease the land to be able to put up the turbines. And so it takes both a lease, which is a use for the surface of the property, a certain use. You can also have an agricultural lease. You can have, a solar, easement and lease. So, lease is use of the land. It's for a shorter term. Usually it doesn't run in perpetuity or forever like an easement. And, you pay a certain amount to be able to use it. That's usually what is a lease. And a lot of like people lease grass, lease land for running cows or something, or they lease it for growing crops. Yeah.
Martha, we have another question.
Okay.
I'll just read it. I think I know what it's getting at here. Is a real estate agent responsible for disclosing that water or roads that are on the property being sold don't necessarily belong to the new owners? And I think that maybe means that there's some type of limitation or easement, or it's a servient estate of some type.
Every real estate agent has a contract with whomever they're representing. And I think if you read that contract, you'll find that they're not responsible for much based on the contract that you have with them. I have been involved in litigation with that. And for the land itself, that's why they have title opinions. So a title company would be responsible to disclose and tell you what was on the property, what easements and different things were burdening the property. And for water rights, we do not have anything in law that protects the buyer or the seller. And as an attorney that does water rights, we do sell an analysis of the water rights. But that has been really an area of law where there's been mistakes being made now because everybody's working so fast and loose trying to sell things. And so if I were buying or selling land that had valuable water rights, I would have some attorney do some type of analysis on that for me. And it's a specialty. Well, I might have said that wrong. Not all attorneys do it. It's a niche practice to be able to give a view of a report on water rights. And it's not only what water rights are there, it's where it's at in adjudication. Because you could be in some places and you're at the beginning of the process and other places that are all the way done. And where you're at in the adjudication process all goes to the value and how much money you're going to have to put into to defend or make sure that your water rights are correct. So. All right, so I decided to include this because what I remember I talked about that wind leases have to also be an easement. We have a statutory description of what easements we have in Montana. So if there's an easement for something else, arguably you could say it's not allowed, because if you have a statute that is this definitive about what you can do for easements, and I'll read through them for you. So it's the right to pasture, the right of fishing, the right of taking game. So these are all things that you can have an easement for. The right of way, like a road, the right of taking water, wood, minerals, and other things. We also have ditch easements that are not listed here, but there's another statute that talks about them. So I'm going back now. The right of transacting business upon land, the right of conducting lawful sports upon land, the right of receiving air, light, or heat from it over or discharging the same upon or over the land. I'm not even sure what that means. The right of receiving water from or discharging the same upon on land. That's kind of like, well, how is that different from a water right? No, but we haven't litigated the statute for a long time. So this is always kind of confusing to me what we're doing here. The right of flooding land. Now, I'm not sure why that's an easement, not a water right. The right of having a water flow without diminution of disturbance of any kind. So again, here's a place where we have lots of discussion about water rights that seemingly is very similar to the property right itself and not an easement. But we have statutes on the books that we haven't necessarily trued up to what's happening now. And then here's another one, the right of using a wall as a party wall. That's interesting. I'm not sure what a party wall is. Your box is over I can't see this one.
The right of a seat in church. That's a new one for me.
I know, right? Yeah. And then the right of burial, you can have an easement for that.
How often do these non-right-of-way easements come up in your practice, Hertha?
The only thing that I've seen it mostly was with those wind leases that, once we passed the statute that talked about wind leases, that some companies didn't use it. So,
and assumedly all of these types of use rights could be acquired by filing a written document with the clerk and recorder, or even by prescription.
Yeah, I have not yet litigated an easement by prescription, besides the roads. So that is obviously that is what the road is, but I have not seen the other one. So that would be very interesting.
Very interesting. Wow.
Yeah, so I think we've already covered lots of this. So let's go over it again though, because this is where people get in trouble. If you're buying property, you want to make sure that you have a written easement for the access to your property. And ideally, you want one in it, you want two of them. So if something goes wrong with one, you have another one. But at least one. And we talked about by prescription and county road, and this is how a lot of people try to get it, by hook or crook. I mean, there's so many, the other case that we have right now is in eastern Montana, and it's brothers. So they split up the family ranch. One gets one part and one gets another part, and that when they first split it up, it seemed to be friendly, but now they're not happy with each other. And my clients need to use this extra road to be able to get in and out, especially, with the big trucks and stuff to haul the calves out. Well, the brother doesn't want to let him use the road, so he dumped a whole bunch of stuff in the middle of the road. And we've had it almost settled several times, but it kind of blows up because they don't get along. And sometimes people don't mind spending money, and they kind of like to just fight. So that is another example of, it makes so much more sense for them to resolve it. And we could argue by prescription, but if you're going to go to court and have it decided, you're probably going to spend, I would imagine, at least $50,000, $30,000 to $50,000. So if you may want to offer a certain amount of money to be able to get one and get it written, and then you control the terms and you don't spend all your money litigating. So. All right, so we talked a little bit about wind easements. I do a lot of the wind work for private landowners, and there are wind projects going on right now, and I've actually seen some of the best ones yet as far as how much money they're willing to pay. And a lot of it's in eastern Montana. They found a way to be able to, for a long time, we didn't do a lot of projects in Montana because it was hard to get the wind out. We did not have enough power line capacity to move it to market. And obviously Montana probably doesn't need a lot more energy, even if we have lots of wind. The other problem is Montana's wind is a little bit rough. It's bigger gusts than a lot of places. So they had to also wait till the engineering for the turbines became so that they could withstand the type of wind that we have in Montana. So, but right now there are literally several projects being done, and they're going east with it, and they're also filling up some of what isn't online anymore because of Colstrip. And so I see some of the best deals I've seen. There are wind leases actually for at least 50 years, 50 to 70 years. So if I did a wind lease, I'm probably not going to be around to see the end of it. And a wind lease is very important for, what's in the document. But the places that I have to be really concerned about on behalf of the landowners is, I can tell them what's a good market price. And usually if a wind company is building stuff, they're going to be pretty close to the market, because even though they're supposed to keep all this confidential, those rural landowners talk a lot amongst themselves. So they usually are in the, at the top of the market. So that's not my biggest issue. The biggest issue is what happens with their indemnity clauses. And that means, so if somebody comes and puts up 10 wind turbines on you, and each one of those turbines is worth $3 million, all of a sudden you have $30 million worth of wind stuff on your property at least. And most of the people who have the underlying fee simple, that will dwarf how much money the real property is worth. So if we go, head to head, or we have exactly the same indemnity clauses, so one of your hunters, or maybe your son's friend from high school comes out and goes hunting and goes on a wild run and starts shooting those wind turbines, you can rack up some pretty high indemnity. Indemnity means that if something happens by you or somebody you invite to their property, you have to cover it, you have to pay for it. So I say that's not fair, and I try to make it so that the landowner's indemnity is limited to a certain amount, or their amount of their insurance. Because it's like that, my client shouldn't lose their place because they were willing to do business with you. The other thing that we're really concerned about is fire. Those turbines can come down and they can create a fire. And if the wind company starts a fire and it goes across your land through the neighbors to the Forest Service, and then after that, they come back on you because the wind, the fire got started on you, and the wind company is a shell company. It's a Montana LLC, and they don't have a ton of money in it. I'm very concerned that they have liability for what they cause, especially with fires, and that they are actually funded enough to be able to pay the damages. So those are some of the things that people don't naturally think about with a wind easement, but those are very important. And then they also have to keep it from being any liens, like when they're doing construction. To put up those wind turbines, they bring in a crane that comes on, I think, 6 trucks to be able to pick them up. So everything they do out there costs a ton of money. And you want to make sure that the landowner is protected, and that if they don't pay the guy who owns that truck, that they don't put an easement on the real property and the landowner gets stuck holding the bag. So ditch easements are, again, they're a creature of law by statute. And if I have a water right that's carried by a ditch, I automatically have a ditch easement to carry that water to my place. So even if I don't have it, it's not been spelled out in writing. If it's been used historically, it is a property right. And we have litigated cases about where people have tried to deny somebody their ditch easement, and that goes to scope. And note that if you don't use your water rights, you can lose it. You have to use it or lose it. And so the question is, if I haven't used my water right for 30 years, do I still have a ditch easement? Probably not, but that's also an area that is still hasn't been clearly litigated, and we don't have clear law. I think you can make a case, and that's certainly what I would do. But that's another thing. If I were buying property, I would want to know what ditches were out there, who owned them, and how long it's been since they used them, and if somebody else was going to claim them. Because if there is a ditch easement, then you could be litigating about whether or not you can bring water. They can bring water through your place. This is another picture from our ranch. Not very far from there, if you look back where the sun's coming up, that's actually a place where there is a wind farm by Martinsdale. You just can't quite see the hill where the turbines are. Boy, this is where it gets really hard now. You think water rights are hard. Mineral rights are what's called a split estate. So that means when much of Montana was settled, they had different homestead acts. And the homestead acts, created how many acres you could get, who could get it, and that all depends on the year. But at some point, they decided that they had to protect, the nation and not give all the rights, the mineral rights, to the people who got the land. And so then we created what's called a split estate. And that means that the people who own the surface estate do not own the right to minerals underneath. So I have some clients in the middle of the state where some of the old oil wells were, and they have lots of old oil wells on them, but they don't get any benefit from that. And somebody else owns the mineral rights, so the oil company pays them royalties, and they're supposed to not impede or damage the surface owner. But there's going to be lots of cases, I think, in the future too, because a lot of these producing wells are at the end of their life. And at that time, I think some of the people who own them will probably want to leave them and try to, skip out on some of their potential liability to clean up. I hope that's not true, but that very well could happen.
And
So
Hertha, I don't know if you know this, but is the split estate where you have a different mineral rights and surface rights, is that all over in other states, or is that just in the West, or is that just in Montana, or is that everywhere?
it's just in the West, and it's the later states, because it was, so you have to think about, Montana, we were one of the later states to become a state and then to be homesteaded. So, but I think there's some in Wyoming and Idaho. So I think as the further you go west, the more you have split estates. And I'm not sure about North Dakota. I don't know my history well enough to know that. Um,
And there was a case about dinosaur fossils recently, right? I can't
yes,
remember. Is it dinosaur fossil minerals or not?
oh my God, I knew you were gonna ask me that. Um,
I can't remember either, but I think that they ended up being mineral rights, right?
and not, I don't remember for sure, and after 29 years, if I don't remember for sure, I say, I don't know.
Oh, fair
There
enough.
was,
Fair
there
enough.
was a recent case, and, it was highly fought over because, it was a big deal about who owns the, dinosaur. So, can't look it up fast because, I'm on my screen, but, I would have to look it up again.
No worries.
Right.
Didn't mean to put you on the spot there. I can't remember either.
Better than saying it wrong, right? So this is my favorite topic. I went to law school because, after my family, we, used to ranch in, Lewistown, Zortman, Browning, and, when I was in college, it was in the, eighties, early eighties, and, we got caught upside down, which meant we had borrowed a lot of money to move from one ranch to another one, and interest rates went way up, so we could no longer, cover our debt with how much land we had. They literally came to our ranch and loaded up our cows. I mean, I had pretty rough things happen as a child, but this is the only time I lost time. I don't remember certain parts of that. And so, I was very, concerned about losing our ranch, and that was what we did as a family. We grew up as a ranching family. So after I went to pre-med school at Montana State, then I decided I was gonna, they told me I should be a writer, because I started writing about some of the policy issues affecting Montana. I went back to Temple University in Philadelphia and got a degree in journalism. And from there, I ended up being a journalist covering Congress and the United States Supreme Court. While I was covering the United States Supreme Court in 1990 or 91, they had a case called Lucas versus South Carolina, and that's one of the premier Fifth Amendment takings cases, kind of ever. And as I covered that case as a journalist, I decided I did not want to just be a journalist. I wanted to do it. I wanted to become a property rights attorney and protect people and their land. And so that's one of the main areas. I don't do a lot of it because we don't have a lot of eminent domain in Montana, but I have done, numerous cases around the state. And the eminent domain is like saying the Montana Department of Transportation is going to widen a street or put in a new road. They sometimes, if there's not a willing buyer, willing seller, they have to use eminent domain, which means, the government, as well as other, usually the government, but some private entities, which I'll get to when I talk to you about Mattel, can take property for public use so long as they use, due process, and they pay just compensation. So usually the government will offer to pay, a decent value, but I didn't do this research, but some of the attorneys before me that who used to do a lot of the eminent domain work, they found that once you got an attorney involved, they would get paid, twice or three times as much as the original offer. So obviously it must not have been fair market value. And I can't, as an attorney, I can't get any more at trial than fair market value. So it means fair market value is what an appraiser will say it's worth based on how his analysis and him being an expert at looking at what similar land in the area sells for. However, in Montana, not every state has this, but if the landowner prevails, whoever is the condemnor has to pay my attorney's fees. So I've had cases where my client only got paid like $50,000 for the property, but they got paid two or three times that for the attorney's fees. So it's a big deal, and our legislature did that when they passed the new constitution, because they felt like if the government was going to take your property, it shouldn't cost you money if you prevail, and they didn't give you a fair deal up front. Now, in some circumstances, a private industry, and Mattel was it was a power line that they were building with money. I call it funny money. It was when they were trying to jumpstart the economy and they decided they wanted all these, I don't know, I had the name for a second, but they were handing out federal dollars to be able to get projects moving, to be able to build jobs. And this was a power line from Great Falls to Canada. And it happened to go through, I represented several, like 20, 30 different landowners up there, and it went through their place. And my clients were not opposed to the power line at first. They just wanted they wanted to be treated fairly. And they also wanted to have to say on where it went because the company wanted to put it in some places that really didn't work well for the landowners, but also it was a bad place to put a power line. But the other mistake they made is they put it across a Native American's land and they wanted to go across teepee rigs. And so I won a takings case in district court that they couldn't go run across that landowner's property because it would be a taking. So they would have to, they were trying to just force it through. And then the legislature actually passed a law to make it approve it retroactively, which I'm like, I didn't know you could do that, but it was a pretty big battle. And so then we litigated, it's three different district courts, multiple cases. But at the end of the day, the company ended up paying my clients, the landowners, fair market value. And it would have been much easier for them to do it upfront, to do it correctly. And at this time, there was a new power line going in on the eastern side of the state. And that company is actually doing it by negotiating with the landowners, with using just fair market, willing buyer, willing seller. And I think there's a question whether or not they could get, they have to go through Major Facility Siting Act to be able to get authority to condemn, but they're not relying on condemning. They're relying on being a good company and negotiating with the landowners. And I've never done any work with any company that's better than they are for how they're treating the landowners. And they're paying decent money. So, it's a breath of fresh air because they're trying to be good neighbors rather than rely on eminent domain.
So Hertha, we have another mineral rights question, and I did a quick search, and the dinosaur fossil case did say that dinosaur fossils are not minerals, so they were the property of the surface owners. So just to clarify that. But there's a question about mineral rights. Are they ever insurable in Montana?
Not at this time. And so using my husband's family, his ranch, the land has been in his family since before Montana was a state. So if you go back that many years, and then usually what happens with mineral rights is, so they're already a split estate, some of them are not. And then let's say, there's 5 sons, or 5 people, and it goes down to the 5 sons. And then the mineral rights go here, and sometimes it gets split from the fee simple. Mineral rights are incredibly hard to track. There's a whole business out there to do that, which is not very big right now because we haven't had a lot of oil and gas development. The only way people work, will spend all that time going to the courthouses and trying to figure out who owns it. So it is not insurable, and there are experts who have done that in the past, but they're really hard to find right now because the oil and gas business in Montana is pretty slow. I think we might have already talked. Okay, boundary line issues. Many fences are not on the boundary line. And so when you buy land, you might want to be aware of that. And so the question is, well, what happens if, the boundary line, like on my husband's ranch, the next door neighbor, we're all friends and they're actually cousins. And the fence is off because it didn't make sense to put it on the boundary line. Does that mean that when, they go to sell the place that this is the new boundary line where the fence is? Or does it mean that they have litigation against, and note that once this land, if it leaves these families, nobody's going to remember why they did what they did. And so I have some people coming to me who've bought, you know, in less rural areas than we are, and, you know, the fence isn't in the right place. You know, so those are on other issues where you can buy something or sell something that has litigation fraught in it, so. And, whenever you're changing from agricultural to recreational or residential uses, there's also ongoing issues because of the change of use. I mean, so with agricultural, we have, you know, the water rights. So it used to be a lot of flood irrigation. Well, with flood irrigation, you know, that created a certain dependence on all the downstream users because of the flood and how it worked. If you switch to sprinkler, you know, that changes how much water flows, and that becomes a kind of an issue. But let's say you go from agricultural to residential, so now you're no longer irrigating, and then let's say the landowners who it's been subdivided to, they don't do anything to use their water rights or split them. So now you have some water rights hanging out there that aren't being used. If they're not used for 5 years, you lose them. Yeah, so there's all types of different issues that you can get into. And no, when I say recreational, a lot of ranches now are sold for what's called recreational use, and that's for hunting. And the value of Montana land is so high for recreational, for other uses. If you were straight agriculture and tried to pencil it on just agriculture, you probably could not afford to buy much of the land that is, you know, available now for just agricultural, and how much you can make from using it for agricultural purposes. So that's another thing to really be aware of, that, you know, Montana land is worth more than it is value, you know, than what you can make off it for agriculture.
Wow. Hertha, we have another question. Someone is asking, when in law school do you have to specialize in property law to be a property rights attorney?
Well, in law, we don't necessarily specialize at any time, because we're not supposed to say that we're specialists. However, to be, you know, everybody studies property law early on in law school. And everybody, once they get out of law school, we all kind of go our direction about what we're passionate about. Well, hopefully we can. I mean, I was fortunate enough and strong, bullheaded enough that I made my way, and I've always done property. And it is my niche. We're allowed to have a niche. And so it's like anything else. If that's what you want to do and you want to go to law school, you know, pay attention in law school, take all the courses you can, and then, you know, try to find your first job. I have a young man coming to work for me next year, and he come to see me when he was in high school. He's from over by Harlowtown. He come in high school. I was working for his dad on a case, and he told me then that he was thinking about going to law school. Now he is in law school at Texas A&M, and he came and interned for me last year, and he said it was his dream to work for me. And so I said, I'll give you a chance. So I think that those things can still happen, you know, that it was in his mindset that he wanted to do property law, and you know, I'm very happy that's what he wants to do, and I'm really happy to mentor him and to bring him along. So I think that does work. There is the opportunity still for mentoring in the law profession. I think this might be my last slide, so I hope we have some more questions, because I might be done early.
Yeah, please feel free to drop some more questions in the Q&A. To have an expert like Hertha available to us is just a real treat. And in the meantime, I have a couple questions. Oh, we got another one. Hertha, on boundary lines, if a residential property survey shows the real property line is outside of the existing fence, thereby making the property larger, and that survey is filed with the county, do you have to then make any changes to claim that property is yours?
The survey is proof of the boundary line. And then your next question, though, is do you want to, you know, put the fence on the boundary line? Because if you don't put the fence on the boundary line and somebody else is using your land, it's let's say it impedes on you, you're losing, you know, ground. And they could develop a claim, you know, that they've used it open and notorious for 5 years and it's now theirs. So, if I were in an urban setting and my fence was off, I would look at how much it would cost to fix it. Cause that's probably still less than it would be to cost to litigate if somebody wanted to try to take it by adverse possession.
Interesting. I've seen a lot during this election cycle about public lands and that being a really big issue in Montana. Can you tell us what is public lands? What do you have a definition for what that term means?
Well, I think people use it, it's a misnomer to a certain extent. I mean, I think they're talking about, Montana the western states has we're a third owned by the federal government, and that's land that's in parks, Forest Service, or the Bureau of Land Management. So those, they might say those are public lands. I think more technically, they're Forest Service lands, they're Bureau of Land Management lands, and the public has certain rights to use those according to those agencies and their rules. We also have state land, and in Montana, we have when we were developed, there were school sections, and those are to be managed for the benefit of the school trust. And we also have state parks. So in a sense, the global term public lands is a little bit of a misnomer. Also, as far as issues, and I know we talked about this a little ahead of time, so I was thinking about it driving here. It's a political issue. I am not sure it's much more than that. Because the reality is, I know they're saying that some people are going to, try to get rid of the public lands. It would be almost impossible, and I'm not even sure you could get, I'm pretty sure you could not build enough of a consensus to get rid of public lands. I mean, there's so many different interest groups that rely on how these lands are managed. I mean, you have the people who use them for recreation, but even the ranchers, when they, like, say maybe they use them for, pay for grazing. If you were to change how we handle public lands, it would change the whole playing field, how many people who own land in Montana and recreate or utilize and share in the lands that are owned by the state or federal government. I mean, I just can't see a coalition coming to be able to change that. So I do think there's a potential for more bill laws to be able to take some of the lands that are currently like Forest Service lands and try to turn them into, more more roadless or something. So that is possibly something that could happen. There's probably you could build enough, get it through, a certain Congress on that. But no, you have to pass something in Congress, and I don't know how many laws have passed, but I think you can count them on maybe one hand right now. I mean, Congress is pretty dysfunctional. So to me, that's a political issue. There's not a lot of reality in, some of the things they're saying about public lands. And
Interesting.
to be
So let me
honest, ranchers and environmentalists, are probably more talking to each other now more than ever, because environmentalists, I think, would prefer to have land and agriculture than developed. So, some of the issues that existed when I first started 30 years ago are not as hot at issues right now, and what people call the public lands issues. That's my experience with what I know right now.
Do you think that if the dollars just don't pencil for new agricultural use in Montana right now, how do you think that leaves that issue and the possibility of everybody being happy with agricultural use as one of the main uses for Montana land?
Well, I didn't say that we're still not using it. What we're doing is we have buyers who can afford to pay recreational use and still have a ranch in Montana. And that's not necessarily, your regular people who want to, like my nephew, is making a go of, leasing places and stuff. It's very, very hard for a young person to buy into agriculture nowadays. So I think it will still be in agriculture, but you will have more and more people who have accumulated money other places being able to buy out, and outcompete, your regular middle of the road people from Montana. And
Yeah.
it's also a little bit the same issue like with American Prairie Reserve. And so I work a lot for some landowners around there, and the ranchers themselves don't want the neighboring land to go to the American Prairie Reserve, because if they buy it and then put buffalo on it, it lessens how much money the counties make for taxes and everything. And so, but they can't compete because the American Prairie Reserve, has non-profit dollars, and they can spend more than it's worth. So I've heard of places going for, a third as much, or much more than market value for the places. So there's lots of competition right now for Montana ag land, and it's not necessarily regular farmers and ranchers that are to be able to compete.
Oh. And it doesn't sound like that might be changing anytime soon.
No, we're still the last best place, and we can all thank Yellowstone for making us even more popular, right?
Yeah, exactly. We have had a bunch more questions, but we're getting close to time. One of the questions is whether these are going to be recorded, and the answer is yes, this is recorded. And all the recordings for this lecture series are put on the Montana State Bar website, and they're available for the next year. So if you have any desire to listen again, absolutely, they're available. Lots of really good detailed questions here that I think that Hertha would be a great person to follow up with for those detailed questions. There's only one more question I think that might be really generally applicable, and that's if you can, Hertha, do you suggest a survey with a property sale? Do you suggest getting a survey done with a property sale? Or does it just depend on the situation?
Depends on the situation. If you're in a place that's been developed, there will be a survey. If you were buying a ranch, you can't afford to have a survey. So it depends on how many acres and where you're at.
Mm-hmm.
Yeah, but I would definitely, want to have somebody, looking at the water rights and the road issues. I would not just go by what the realtors said, because that you hire them to do a land deal. And they know some things about that, but that's not, they don't indemnify you on that, and it's not necessarily what they're good at.
Do you find it pretty accessible to go to county clerk and recorders in more rural counties where large land deals are being done and get that figured out, the property rights and the water rights and the easements and all of that?
Well, for property rights, you can go and look at it, and anybody who has time and is, willing to delve into it can figure that out. You have to know how to read a map and all that. Water rights, you can't find that locally. That's a whole, you have to be able to look at the DNRC and at different websites and the water court. And that is, most attorneys can't, there's probably 20, 30 attorneys in Montana that's their niche.
Mm-hmm. And can you break down briefly what the difference between an adjudicated and a non-adjudicated water right is?
An adjudicated water right is one that's been through the process and has come out in a decree. And that means that, so there's been, the process is there's objections, those objections are resolved, or they're litigated and resolved that way. But one way or the other, it will be trued up that we know how much water there is, and how many acres and all that. And an unadjudicated water right, which there aren't very many, there's only a few basins that they haven't gotten to, is one that has not yet been gone through the process. But we're getting very close to, I mean, they've worked really hard, and the water court has, made, I'm amazed at how much they've gotten done in the last, say, 5 years.
So now that a lot of water rights are adjudicated, does that make it easier for buyers to figure out what's going on?
It does. However, we don't have final decrees yet. So the question is, you have a preliminary decree, so you're almost there to getting the final one. Is there anything left in the process that can, cause a wrinkle in your property right? That's what I would want somebody to tell me.
Interesting. Wow. Well, Hertha, on behalf of the Montana Bar, I want to thank you so much for this time. It's like I said, it's such a treat to have such an expert like you, and thank you for your service to the state and the people of Montana all these years. It's much appreciated, and your time tonight is really appreciated. Thanks also to all the attendees here. Thank you for attending, and hopefully we'll see you next week when we're talking about generative AI and the law. I think the title of next week's lecture is My Attorney a Robot? So please tune back in, and thanks again, Hertha. Much appreciated. Have a good
Thank
night.
you. Good night.